Hi there, it's Friday the 30th of August 2019. I'm Steve Towers. Welcome to ITB. Let's get started. The French and US governments have reached an in-principle agreement in regard to DST. Announced by Presidents Macron and Trump at the end of the G7 Leaders Summit in Biarritz, the agreement is that French DST paid by non-resident companies will be reimbursed when the Inclusive Framework's global solution is in place. President Macron was quoted as saying this: "The day international tax exists on digital services, France will do away with its national tax, and everything that has already been paid under the French tax system will be reimbursed." Officials explained that the plan is for each company's DST payments in 2019 and 2020 to be credited against its French tax liability under the global solution, with any excess to be refunded to the company. French Finance Minister Le Maire will meet with US Treasury Secretary Mnuchin in the coming days to agree the details of the plan. But you have to ask the question, what will happen if there is no global solution? And in regard to the global solution, Pascal Saint-Amans said this week that the France-US agreement on DST will increase the prospects for a global solution. A proposed global solution will be published by the OECD Secretariat in late September or early October for discussion by the G20 finance ministers at their meeting on the 17th of October. And the OECD expects to give countries within the inclusive framework an idea of the revenue impact of the proposal in September. Last Friday, both countries came out shooting. First was China. In retaliation against the recently announced US tariffs to be imposed on the 1st of September and the 15th of December, China announced additional tariffs of 5% and 10% on $75 billion of US origin imports into China. These new tariffs will take effect on, yes, you guessed it, the 1st of September and the 15th of December. China also announced that effective the 15th of December, it will resume imposing 5% and 25% tariffs on US origin vehicles and parts. For a copy of the announcement by China's Ministry of Finance, please go to our website or app. And then it was the US's turn. Later that day, the US government announced a new round of tariff increases. Firstly, the 25% tariff on $250 billion of Chinese origin imports into the US will be increased to 30% effective the 1st of October. And secondly, the 10% tariff on $300 billion of Chinese origin imports into the US will be increased to 15%, effective on the already scheduled dates for tariff increases on these imports. For a copy of the statement issued by the US Trade Representative, please go to our website or app. In Australia, the tax authorities have released for public comment draft guidance in regard to the arm's length debt test under the thin capitalisation rules. The draft guidance includes this important statement. While the arm's length debt test in some respects draws upon arm's length concepts that are broadly common to transfer pricing, The test itself is not a transfer pricing analysis, nor does it necessarily proxy an outcome consistent with the arm's length conditions under Australia's transfer pricing rules. Rather, it requires an overlay of factual assumptions that produce a hypothetical entity against which specific factors are to be assessed. Public comments are requested by the 9th of October. For a copy of the draft guidance, please go to our website or app. In China, the National People's Congress has approved a new resource tax law to be effective the 1st of September 2020. The new law gives local governments the power to tax 164 different resources, including fossil fuels and minerals. The law also provides for the introduction of a water resource tax that is designed to encourage efficiency and conservation. For a copy of the new law, please go to our website or app. In India, the Finance Minister announced a package of measures to achieve higher economic growth in the country. The latest data shows that the economy is growing about 2 percentage points below its potential growth rate. There are only 2 substantive tax changes announced in the package. The first is that the newly enacted increased surcharge on short-term and long-term capital gains derived by foreign portfolio investors on the transfer of equity shares or units will be repealed. However, the increased surcharge will remain on the transfer of other securities. And the second is that the so-called angel tax, which imposes a tax liability on startups which raise share capital in excess of the fair market value of the shares they issue, will be eliminated for startups registered with the relevant government department. The package also includes a number of tax administration simplification measures. For a copy of the Finance Minister's presentation deck, please go to our website or app. Also in India, the High Court of Calcutta has decided a case in regard to the non-discrimination article in the India-Japan Treaty. The relevant provision is Article 24.2 of the India-Japan Treaty, which corresponds to Article 24.3 of the OECD Model Treaty. Article 24.2 says this: the taxation on a permanent establishment which an enterprise of a contracting state has in the other contracting state shall not be less favourably levied in that other contracting state than the taxation levied on enterprises of that other contracting state carrying on the same activities. The facts are quite straightforward. A Japanese resident bank operated in India through a PE. For the relevant year, which was 1991, some tax cases seem to take forever in India. Indian domestic tax law levied a higher income tax rate on foreign companies than on domestic companies. The issue in the case was whether that rate differential breached Article 24.2, with the consequence that the lower domestic company rate would apply to the Japanese bank. As I'm sure you know, that rate differential is still in place. And as far as Article 24.2 is concerned, it was very easy for the court to conclude that yes, the rate differential does breach the provision. But the elephant in the room, of course, is Explanation 1 to Section 90 of India's Income Tax Act. Section 90 gives the government authority to enter into double tax treaties and gives the force of law to such treaties. Explanation 1 currently says this: for the removal of doubts, it is hereby declared that the charge of tax in respect of a foreign company at a rate higher than the rate at which a domestic company is chargeable shall not be regarded as less favourable charge or levy of tax in respect of such foreign company. Explanation 1 was introduced into the Income Tax Act in 2001, but with effect from 1962. And so the timeline looks like this. Let me start in 1990. The India-Japan Treaty becomes effective. 1991 is the relevant tax year to which the case relates. 2001 is when Explanation 1 was introduced into the Income Tax Act, but with retrospective effect all the way back to 1962. And 2019 is when the court delivered its decision. So, as you can see, in view of the retrospective effect of Explanation 1, it should have been relevant and in fact decisive in this case. But strangely, there's no reference to Explanation 1 in the court's decision, and it has effectively not been applied by the court, which makes me think that the court has refused to give Explanation 1 a retrospective operation. And that wouldn't be the first time that an Indian court has refused to give retrospective legislation its retrospective effect, in situations where it is clear that there is no doubt to be removed. But nevertheless, it is still curious that no reference to Explanation 1 was made in the court's decision. Of course, another possible explanation, please excuse the pun, is that this was simply an oversight by the court and by counsel for the tax authorities, and not just an oversight of Explanation 1. There would also be an oversight of the several tribunal decisions which have applied Explanation 1 to allow the higher tax rate to apply to a PE, including at least one tribunal decision in regard to this same taxpayer. Bearing in mind that, to my knowledge, this was the first time Explanation 1 was before a court, then oversight is hard to believe. One final point to note is that there could be an argument that Article 24(2) doesn't apply to the tax rate differential which exists in India, regardless of Explanation 1. Article 24(2) requires a comparison of the Indian taxation of an enterprise of Japan and the Indian taxation of an enterprise of India. Under the definition in Article 3, enterprise of a contracting state means an enterprise carried on by a resident of a contracting state. And so the comparison in Article 24(2) relates to the Indian taxation of a resident of Japan and the Indian taxation of a resident of India. But India's tax rate differential is not based on residence. It's based on country of incorporation. Foreign companies are subject to the higher rate, and domestic companies are subject to the lower rate. So maybe it's not Article 24(2) which is relevant, but instead Article 24(1), which is based on nationality. And of course, Article 24(1) has its own interpretation challenges. I'll leave all of that for another day. For a copy of this decision, please go to our website or app. Also in India, the Delhi Income Tax Appellate Tribunal has delivered a decision in regard to fees for included services under the India-US Treaty. Fees for included services is commonly called fees for technical services in most other Indian treaties. The US parent company of a multinational group entered into a global agreement with its group entities, including an Indian company, for the provision of support activities in regard to supply chain, HR, strategic planning and marketing, finance, and information systems. The agreement allocated costs with no markup using an allocation key. The issue in the case was whether the amount paid by the Indian company was subject to Indian withholding tax under Article 12 of the treaty. Here's the relevant part of the definition of fees for included services in Article 12(4) of the treaty. You will notice that the definition has two requirements. Firstly, the payment must be for the rendering of any technical or consultancy services. And secondly, those services must make available technical knowledge, experience, skill, etc. The taxpayer made two arguments. Firstly, the payment was a reimbursement of costs, and therefore it was not for the rendering of technical or consultancy services. That argument was rejected by the tribunal. And the taxpayer's second argument was that the make available requirement was not satisfied. That argument was also rejected by the tribunal, which said this: the concept of make available requires that the fruits of the services should remain available to the service recipients in some concrete shape, such as technical knowledge, experience, skills, etc., which is met in the instant case, as can be reflected from the nature and duration of the contract. I think this means that the nature of the services and the fact that the agreement was of long duration means that the Indian company's employees would be likely to acquire some technical knowledge, experience, skill, etc. from the performance of the agreement. For a copy of this decision, please go to our website or app. In Indonesia, the government has issued a regulation which reduces the tax rate on interest payments on bonds to 5% up to the end of 2020 and 10% thereafter. Bonds are defined as debt securities, state debentures, and regional bonds with a maturity of more than 12 months. For a copy of the regulation, please go to our website or app. In Singapore, the tax authorities have issued updated guidance in regard to the imposition of GST on inbound B2C and B2B digital services, effective the 1st of January 2020. For a copy of the updated guidance, please go to our website or app. In Taiwan, the legislation which provides incentivized tax rates for the repatriation to Taiwan of offshore profits became effective on the 15th of August. During the next 2 years, qualifying repatriations will be subject to either an 8% or 10% tax rate. September will be a big month for the European General Court in regard to high-profile state aid cases. I mentioned in last week's ITB that the hearing for the Apple case has been scheduled for the 17th and 18th of September. Well, on the 24th of September, the judgments will be delivered in two other state aid cases. APAs granted by Luxembourg to Fiat and APAs granted by the Netherlands to Starbucks. In fact, in each of these two cases, 2 judgments will be delivered, so 4 in total. Challenge of the EU's Fiat decision by each of Luxembourg and Fiat, and challenge of the EU's Starbucks decision by each of the Netherlands and Starbucks. In Italy, the tax authorities have released guidance in regard to the tax treatment of profit distributions by Italian real estate funds to Singapore REITs. The guidance indicates that due to the special features of Singapore REITs, such profit distributions will be exempt from Italian withholding tax. For a copy of this guidance, please go to our website or app. In Nigeria, the executive chairman of the tax authorities has announced that the proposed imposition of VAT on online transactions involving goods and services will commence on the 1st of January 2020, subject to final government approval. the existing VAT rate of 5% will apply to these transactions. He estimated that the equivalent of $3.6 billion of VAT could be collected each quarter from this initiative. 2 points should be noted. The VAT will apply to both domestic and inbound online transactions, and collection responsibilities will be given to Nigeria's banks. In Chile, the revised tax reform package has been approved by the lower house of Congress. It will now be submitted to the upper house, the Senate. In Colombia, the tax authorities have issued a regulation in regard to the alternative VAT collection system for foreign digital service providers. Since the 1st of July 2018, foreign digital service providers have generally been required to register for Colombian VAT and attend to all of the compliance obligations in regard to B2C transactions. Under the new regulation, foreign digital service providers can now elect to switch to an alternative VAT compliance system. The compliance would be undertaken by financial intermediaries, such as credit and debit card issuers, sellers of prepaid cards, and other intermediaries facilitating payment. The new system will start on the 1st of February 2020, except for prepaid card sellers, where the new system will commence this Sunday. In last week's ITB, I discussed the recent decision of the US Court of Appeals for the Ninth Circuit in the Amazon case. Well, there's one aspect of that decision which has been generating a lot of comments this week. That aspect is the footnote at the start of the decision. This case is governed by regulations promulgated in 1994 and 1995. In 2009, more than 3 years after the tax years at issue here, the Department of Treasury issued temporary regulations broadening the scope of contributions for which compensation must be made as part of the buy-in payment. In 2017, Congress amended the definition of intangible property in Section 936H3B, which is incorporated by reference in Section 482. If this case were governed by the 2009 regulations or by the 2017 statutory amendment, there is no doubt the Commissioner's position would be correct. 3 comments are worth noting. The first is that this footnote is obiter dicta and is therefore not binding on other courts. The second is that, nevertheless, the footnote is a very clear message from a senior court. And the third is that the 2009 regulations themselves might be subject to attack under the Administrative Procedure Act, similar to the position of the taxpayer in the Altera case. Also in the US, an agency of the US Congress has published an updated report on the international aspects of the 2017 US tax reform legislation. The document provides a good explanation of GILTI, FDII, BEAT, and so on, and is only 47 pages. For your copy, please go to our website or app. And on the 1st of October, there will be a major expansion of the number of states which impose sales and use tax obligations on remote sellers and online marketplaces, in response to last year's Wayfair case. 7 states will implement an economic nexus test for remote sellers, and 12 states will impose collection requirements on online marketplaces. And now for this week's treaty developments. And this has been another slow week. All we've had is one treaty signed and one treaty enter into force. I have two articles for you this week. The first article is called Recent Developments in the Taxation of Indirect Share Transfers in South America. Lessons and Challenges from Chile, Colombia, Peru, and Uruguay. It's written by Gonzalo Sufiotti and Carolina Marci, and it's published in the IBFD's Bulletin for International Taxation. As the title indicates, this article considers the domestic law rules for the taxation of indirect share transfers in 4 South American countries and their interaction with double tax treaties. And in regard to treaties, the article includes an analysis of the impact of 77 treaties concluded by the 4 countries. 2 particular points are noted. Firstly, the indirect share transfer rules in the 4 countries are not limited to situations where the underlying property which creates a nexus is immovable property. Shares in a source country company or other assets located in the source country can suffice. And secondly, many of the 77 double tax treaties permit the indirect share transfer rules to apply, even in the situation where the underlying property is not immovable property. The authors write this: of the 77 tax treaties analysed, the applicability of ISTRs would be precluded by a lower number of tax treaties in cases involving the indirect transfer of immovable property situated in the source country, that is, 28 tax treaties, or 36% of the sample analysed. In situations involving the indirect transfer of other shares not deriving value from immovable property, the application of domestic ISTRs would be precluded by a higher number of tax treaties, that is, 56 tax treaties, or 73% of the sample analysed. The text and wording of some of the tax treaties analysed have not prevented the tax authorities from adopting more aggressive interpretive positions in situations in which the provisions of the tax treaty in question do not encompass indirect transfers. Although this interpretive position may provide a practical tool for tax authorities to deal with indirect transfers, it may be at the cost of potential unilateral treaty override or multiple taxation. The second article is also on the topic of indirect transfers. It's called Indirect Transfers: What is an indirect interest in immovable property in the natural resource sector and what is it worth? It's written by Jonathan Schwartz and it's published in the CLUA International Tax blog. This is the third article by the author on the recent Australian case RCF4. The previous 2 articles are also available on the CLUA blog. In this article, the author considers 2 issues. Firstly, the meaning of the phrase real property in Articles 6 and 13 of the Australia-US Treaty, and in particular in regard to 3 types of assets: mining leases, general purpose leases, and a licence issued under mining legislation. And secondly, valuation issues in determining whether the wholly or principally test in Article 13 is satisfied. The author concludes, the case illustrates the need for a very detailed analysis of the rights and assets in order to determine whether real or immovable property is involved. It also identifies a shortcoming in the rules relating to indirect transfers, where more than half of the value of shares is reflected by immovable property situated in a particular state. All of the gain on the alienation of those shares becomes taxable. This is true whether in effect all of the value is based on such immovable property, or it is only fractionally above one half of the value. And I would add, this is true even if the whole of the gain is derived from the assets other than immovable property. Well, that's the way it is this Friday, the 30th of August, 2019. I'm Steve Towers. Have a great weekend.